Good evening, good afternoon. My name is Stefan Schohe. I'm a German and European patent attorney practicing in Munich in the law firm of Böhmer and Böhmert. As some time in my past when I was still in academics, I was quite involved with computers. This continued a bit when I entered the profession of a patent attorney. And in a way, that's why I'm just standing here. I'm going to talk about the German case law. And you may wonder why, especially German case law. Is Germany so important? Does this person consider himself so important? The reason is that, in fact, 90% of the case law on computer-implemented inventions in Europe comes from either the EPO or the German courts. The remaining 10% is 5% perhaps the United Kingdom, and the rest other countries. A second reason why this could be of some relevance even to this audience is that, as you may know, European patents granted by the EPO can be validated as to their national parts before the national authorities, meaning that the German part of a European patent can be reviewed as to validity before the courts. That includes statutory subject matter. And in fact, the German courts may, and they do, sometimes come to other conclusions than the EPO. You may also know that currently there's a lot of smartphone litigation going on in Europe. About all of it is, of course, computer implemented. And again, 80% of that is taking place in Germany. Ultimately, it will come to the Federal Court of Justice. And I thought it may be of some interest, also for this reason, how the German courts view that. Just by way of explanation, the Federal Court of Justice in Germany is the highest court in civil matters and also in patent matters. They hear the appeal coming up from the Federal Patent Court ultimately on decisions either originating from German Patent Office and Trademark Office or from invalidation actions that are brought before the court in the first instance. If generally the law in Germany is the same as the EPC, and in fact when reviewing a European patent, the EPC is applied, not the German national law. If you ask the German judges whether they have the same approach as the EPO, they will say yes, or perhaps almost, because they do not completely agree. But nevertheless, although we have a concept that largely resembles what Dr. Steinbrenner just explained to you, this concept is sometimes applied a bit differently than before the EPO, and that's the reason of my talk today. Now, why is it so? Part of it is in the legal tradition. Originally, German case law always had the notion something must be technical, and technical meant solid, tangible, or at least electronic. So by tradition, data processing was suspicious and held not to be patentable because not technical. And in the early days, the courts went about like this. They say, well, okay, we have something here that is computer assisted. We look at what the core of the invention is.